This was evidence of consistent attributes such as unique timestamps, uniform PDF conversions at the polling stations, correct polling station mapping, and consistent KIMS reporting from verification to transmission of results. 6. The RTS was configured on a virtual platform network, VPN, and the SIM cards locked to a specific polling station. The server was also configured to accept results only from authorized and properly mapped KIMS kits. In our view, the petitioners failed to produce credible evidence to the contrary. 7. A review of some of the logs presented as evidence of staging showed that they were either from logs arising from the 2017 presidential election or were outright forgeries. In our considered view, there was no evidence of a man-in-the-middle server configured to the IEBC's VPN network, and no evidence was produced to show that the chairperson of IEBC and staff were part of the arranged conspiracy to stage the transmission process. 9. Whether there was a difference between Forms 34A uploaded on the IEBC public portal and the Forms 34A received at the National Tallying Center and Forms 34A issued to the agents at the polling stations. On this issue, the first petitioner's case was that there was deliberate manipulation and tampering with Forms 34A, as demonstrated in the affidavits, to the effect that votes were being deducted from the first petitioner and being added to the first respondent. To support this petition, evidence was contained in the affidavits of Honorable Martha Karua, sworn on 21st August 2022, Celestine Anyango Opio, Arnold Ochieng Oginga, and John Mark Githongo, which was sworn also on 21st August 2022, and a further affidavit sworn on 28th August 2022. Dr. Nyangasi also swore an affidavit on 21st August 2022, and so was Martin Papa, to support that allegation of handing and subtraction of votes. On the other hand, IEBC and its chairperson urged that all Forms 34A transmitted to IEBC portal were not interfered with or manipulated. Further, that the Forms 34A signed at the polling station and issued to the agents were identical to the Forms 34A uploaded on the public portal and delivered to the National Tallying Center at the Bomas. It was contended that in any event, IEBC used the original physical Forms 34A to tally, verify, and declare the presidential election results. This court ordered scrutiny of the forms from the 41 polling stations outlined in the affidavit of Celestine Opio to ascertain the allegation of interference. And this is our finding. 1, there were no significant differences captured between the Forms 34A uploaded on the public portal and the physical Forms 34A delivered to Bomas that would have affected the overall outcome of the presidential election. B, no credible evidence was presented to support the allegation that Forms 34A presented to agents differed from those uploaded to the public portal. The report by the registrar of this court confirmed the authenticity of the original forms in the sampled polling stations. The affidavits of Celestine Opio and Arnold Ochieng Oginga, while containing sensational information were not credible, as the registrar's report confirmed that all the forms 34A attached to those affidavits and purportedly given to them by the agents at select polling stations were significantly different from the originals, certified copies, and those on the public portal. The purported evidence of Celestine Opio and Arnold Oginga, sworn in their respective affidavits, are not only inadmissible, but are also unacceptable. It has been established that none of the agents on whose behalf the forms were being presented swore any affidavit, that there is nothing to show that they had instructed both Celestine and Arnold to act for them. Yet the two have gone ahead to depone on matters that are not within their knowledge. This court cannot countenance this type of conduct on the part of counsel who are officers of the court. Though it is elementary learning, it bears repeating that affidavits filed in court must deal only with facts which an opponent can prove of his own knowledge, and as a general rule, counsel are not permitted to swear affidavits on behalf of their clients in contentious matters like the one before us, because they run the risk of unknowingly swearing to falsehood and may also be liable to cross-examination to prove the matters deponed. We must remind counsel who appear before this court, or indeed before any other court or tribunal, of the provisions of sections 113 and 114 of the Penal Code, that swearing to falsehoods is a criminal offense, and two, that it is an offense to present misleading or fabricated evidence in any judicial proceeding. Section 114 of the Penal Code states, and I quote, "Any person who swears falsely or makes a false affirmation or declaration before any person authorized to administer an oath or a declaration upon a matter of public concern, and at such circumstances that the false swearing or declaration, if committed in a judicial proceeding, would have amounted to perjury, is guilty of a misdemeanor." One of the most serious losses an advocate may ever suffer is the loss of trust by judges for a long time. Such conduct amounts to interference with the proper administration of justice. The contents of the affidavit of John Mark Githongo, which may contain forgeries, are also dismissed for not meeting the evidential threshold. Those averments contain no more than incredible and hearsay evidence. No admissible evidence was presented to prove the allegation that Forms 34A were fraudulently altered by a group situated in Karen under the direction of persons named in the affidavit, and video clip attached to it. As a matter of fact, these two affidavits amount to double hearsay and incapable of being proved at each of the rears. We turn to Form 34A for Gacharaigo Primary School, which was sensationally presented by Madam Judy Soweto, advocate, to show that one Jose Camango accessed the RTS and interfered with the result contained therein. This also turned out to be no more than hot air, and we were taken on a wild goose chase that yielded nothing of probative value. The KIMS kit relating to Songonyo Primary School, which bore the same serial number with another, was admitted by IEBC as an inadvertent manufacturer's error. We are also satisfied that the two kits and other identifying features that were markedly different, including the timestamps and polling code, and therefore nothing turns on this anomaly. Therefore, to the question whether there was a difference between Forms 34A uploaded on the IEBC public portal and those received at the National Tallying Center and those issued to the candidates' agents at the polling station, we have found none. Issue number 4, on whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui, Rural, Kachiriba, Rongai and Pokot South constituencies, and electoral ones in Nyaki West, in North Imenti constituency, and Kwanjenga in Embakasi South constituency, resulted in voter suppression to the detriment of the petitioners, and especially in petition number 5 of 2022. It is common knowledge that IEBC postponed elections for various seats during the general elections of 9th August 2022 due to mix-up of ballot papers in the above-named electoral units. It is the combined case of the first and second petitioners that, in terms of Articles 136, 2A, 177(1), and 181, as read with Article 1 of the Constitution, the chairperson of IEBC had no jurisdiction to postpone elections in those areas. That Section 55B of the Elections Act is inconsistent with the Constitution and therefore void to the extent that it purports to donate to IEBC power to postpone elections in the constituency, county, or ward, contrary to the Constitution, and the postponement undermined the conduct of free, fair, credible elections by depriving the voters an opportunity to vote for all the candidates on the dates stipulated by the Constitution. The petitioners further contend that the postponement of elections and the overall effect of suppressing voter turnout in the electoral units in question, which was prejudicial to him. Both the first and third petitioners also believe that elections were deliberately postponed in Kakamega and Mombasa counties. It was arranged that these areas are considered to be first petitioner strongholds, and as such, the postponement of elections worked to his disadvantage and handed that benefit to the second respondent. These assertions were denied by IEBC and its chairperson. They, however, admitted that they experienced confusion with the printed ballot papers and explained that they only discovered the mix-up on the eve of the election when the ballot papers were being distributed to the polling stations. That as a practice, ballot papers can only be opened on the eve of the election day to avoid any mischief, and that by the time the mix-up was discovered, it was logistically impossible to print and replace the ballot papers in time for the elections. For this claim to succeed, it must be demonstrated first, IEBC had no authority in law to postpone the elections, and secondly, that the postponement was deliberate and calculated to suppress voter turnout so as to affect the result by reducing the petitioners' overall votes. We've looked at the provisions of Section 55B of the Elections Act, which provides for circumstances when elections can be postponed in a particular electoral unit, including in cases of emergency. We are therefore satisfied that on the basis of the foregoing provision, the third respondent and the requisite power to postpone election in the constituencies, counties, and wards in question. Concerning the allegation of voter suppression, We note that voter suppression is generally recognized as a political strategy which takes many forms, but whose practical effect is ultimately to reduce voting by deliberately discouraging or preventing targeted groups of people from exercising their right to vote, and thereby to influence the outcome of an election. It therefore goes against the letter and the spirit of Article 38, which guarantees every citizen the right to make political choices based on universal suffrage. As regards this allegation, it has not been shown that by postponing elections in the named electoral units, IEBC acted in bad faith or was influenced by irrelevant factors and considerations. From the explanation tendered, we are satisfied that the postponement was occasioned by a genuine mistake, which in our view could have been avoided had the members and staff of IEBC been more diligent when they went to inspect the templates in Athens, Greece, where the printing of ballot papers was undertaken. In the absence of any empirical data, we cannot find a basis upon which to conclude, as a matter of fact or evidence, that the postponement affected voter turnout, as a consequence of which the first petitioner alone, as a presidential candidate, suffered disadvantage. At any rate, the nature of the ballot being an individual decision and secret, there may be other factors to which the turnout in the named units can be attributed. From the evidence on record, however, it appears to us that 2022 general election recorded one of the lowest turnouts since the introduction of multi-party political systems some 30 years ago. If there was a low voter turnout, it affected all the 6 categories of candidates, and its explanation, in our view, lies elsewhere, but certainly not a calculated suppression. On the other hand, in rebuttal to these claims, IEBC illustrated with examples to our satisfaction that there was no nexus between the postponement of elections and voter turnout in the affected units, far from the fact that this claim was undoubtedly just another red herring. It has nothing to do with the question under review, and accordingly we reject it and hold that there is no proof that the postponement resulted in voter suppression to the detriment of the first petitioner. Whether there were unexplainable discrepancies between the votes cast for presidential candidates and other elective positions. Issue number 5. The first petitioner was categorical that there was systemic ballot stuffing in certain counties, mainly in the Rift Valley and central parts of Kenya, where, according to him, a total of 33,208 votes were cast for president only, without corresponding votes for the other elective positions. On the part of IEBC and the chairperson, while acknowledging that indeed in some instances there was vote differential between those cast for president and for other positions, but maintained that they were insignificant, and those instances related to votes by prisoners and citizens in the diaspora who only vote for the president but did not take part in other elective positions. The differential also includes rejected ballot papers and stray votes which do not count as valid votes. The well-established principle that the person who asserts a fact must prove it casts the burden upon the first petitioner to demonstrate that there were instances of ballot stuffing of such a magnitude as to justify the nullification of the presidential election. Ballot stuffing, which is an illegal addition of extra ballots, is a type of electoral fraud aimed at swinging the results of an election towards a particular direction. Not a single document has been presented by the first petitioner to prove systemic ballot stuffing. A figure of 33,208 votes relied on in this claim is based on unproven hypothesis that since the number of votes cast for the president is higher than those for other positions, then, without more, it must follow that there was fraud. We find that fraud is a serious criminal offense, and it must be proved beyond reasonable doubt under Section 5N of the Election Offences Act. It is indeed an offense for a person to vote more than once in any election. IEBC has provided a plausible explanation for the vote differential, citing categories of voters who only vote for the president, such as prisoners and Kenyans in the diaspora. There were an insignificant number of stray votes whose combined effect cannot justify nullification of the election. Finally, on this point, a general election in Kenya comprises of 6 different separate elections held concurrently on the same day. Such elections are held by secret ballots, and one cannot predetermine the voter turnout or how voters will vote in each election. None of the parties has flagged anything so significant that it would have affected the outcome of the presidential election vis-à-vis the other 5 elections held on the same day. We find, therefore, there were no unexplainable discrepancies between the votes cast for the presidential candidates and other elective positions. On issue number 6, whether IEBC carried out the verification, tallying, and declaration of results in accordance with Article 138, 3C, and 138(10) of the Constitution. This issue arises from the printings in all the petitions as consolidated. Based on the said printings, the affidavits sworn in support thereof, and the written and oral submissions by parties, two viewpoints regarding the meaning, scope, and application of Article 138, 3C, and 10 of the Constitution have been advanced. On the one hand, the petitioners submit that pursuant to the foregoing provisions, the role of verifying and tallying of votes as received from polling stations countrywide is vested in the Commission as a corporate entity and not the chairperson of the Commission. It is their argument that the chairperson cannot undertake this task to the exclusion of other commissioners. They submit that the language of Article 138(3)(c) does not envisage a situation where the chairperson can arrogate to himself unfettered authority to verify and tally the results at the National Tallying Center without involving the other commissioners. Such action, they contend, would not only be unconstitutional, but would be sufficient ground, without more, to nullify an election of a president-elect. In support of their argument, the petitioners cite the Court of Appeal decision in IEBC versus Maina Kiai and 5 others, as affirmed by this court in the case of Raila 2017. The petitioners further submit that Regulation 87(3) of the Election General Regulations is unconstitutional, to the extent that it purports to vest the power of verification and tallying in the chairperson of IEBC. On the other hand, the first, second, and third respondents submit that power to verify, tally, and declare results of a presidential election at the National Tallying Center is the exclusive preserve of the chairperson of IEBC. According to them, there is nothing unconstitutional about Regulation 87.3 of the Elections General Regulations. The same regulation the respondents submit makes no mention of commissioners other than the chairperson. That's Forms 34A. Submit. For good measure, the respondents submit that Section 11A of the IEBC Act provides that the chairperson and members of the commission are responsible for the formulation of policy and strategy of the commission and oversight. In their view, the Act does not contemplate a situation where commissioners would be directly involved in the verification and tabulation of presidential election results. The task of verification and tallying, as stated by the respondents, is executed by the staff of the Commission under the direction and supervision of the Commission Secretary, who in turn reports to the chairperson. As to whether the chairperson acted unilaterally in verifying and tallying the presidential election results at the National Tallying Center, the petitioners claim that he did. This is what happened. It is the petitioner's case that the chairperson published an illegal Gazette Notice number 4956 of 2022, in which he designated himself as the presidential returning officer, a position unknown in law and the Constitution. Having done so, the petitioner states that the chairperson proceeded to conduct the verification and tallying process to the exclusion of other commissioners, each of whom he had assigned verifiable roles and related to the verification and tallying exercise. On his part, the chairperson of IEBC submitted that although he has the exclusive authority to verify and tally the presidential election results as received at the National Tallying Center, he did involve the other commissioners in the exercise before eventually declaring the final results. He submitted that he did this in the spirit of teamwork. The chairperson of IEBC states that indeed the 4 commissioners were involved in the preparation of the 9th August general elections from the time of their swearing into office all the way to the verification and tallying of results at the National Tallying Center until they withdrew from the exercise just when he was set to declare the final result. Having considered all the parties' submissions, we find that pursuant to Article 138(3)(c) of the Constitution, the power to verify and tally presidential Tallying Center vests not in the chairperson of IEBC, but in the Commission itself. The latter carries out this exercise through its secretariat staff, technical personnel, and vision of the chairperson and the other members of the Commission. In line with this court's decision in Raila Amolo Odinga versus another versus IEBC and